Good morning, this is your Kelso Report for Monday, August 20th, and I'm your host, Clark Kelso. This will be a quickie today because we only have two cases from last Friday. The first is a Ninth Circuit decision certifying a question under the Labor Code to the California Supreme Court. California's overtime rules do not apply to employees who are paid predominantly through commissions, so long as certain thresholds for the amount of commission earnings are met. Essentially, you have to earn about 1.5 times the minimum wage in order to have an exclusion from the applicability of the overtime laws. Well, in Peabody v. Time Warner Cable, the Ninth Circuit was faced with a case where an advertising sales employee for Time Warner Cable, who earned a respectable $75,000 in 10 months, argued that Time Warner nevertheless violated the overtime rules because of the timing of her commission payments. The employee argued that for all of California's Labor Code compensation requirements, the minimum wage threshold must be earned within each work week and paid within the corresponding pay period for which the commission exemption is claimed. She was paid every 2 weeks. Under this calculation, the employee received only $770 per week in the majority of her bi-weekly pay periods, because she received her large monthly commission in only about half of the pay periods. Now, on the other hand, Time Warner Cable argued that the employee's earnings should be calculated based on the broadcast month, which ended every 4 or 5 weeks, so that her commissions counted towards the pay period for which they were earned, rather than the actual pay period in which the commissions were paid. That favored Time Warner because she received a large commission at the end of every broadcast month. Well, the Ninth Circuit did not find any controlling California precedent to determine whether the employee was right or Time Warner was right. So it has certified the following question to the California Supreme Court. Quote, to satisfy California's compensation requirements, can an employer average an employee's commission payments over certain pay periods when it is equitable and reasonable for the employer to do so? And we'll see what the California Supreme Court does with that one. Our next case involves banking law, an interpretation of a credit union bond. The plaintiff in Universal City Studios Credit Union versus Cumis Insurance Society was a credit union. It had processed a fraudulent wire transfer request, sustaining a loss of around $250,000, and sought to recover its loss under a credit union bond issued by the defendant, which declined to pay. The trial court granted summary judgment in favor of the defendant, concluding that the credit union had not complied with the security procedures set forth in the bond agreement. The Second District agreed with the trial court. The bond required that for funds transfer coverage, the credit union had to conduct a callback verification or use some other commercially reasonable type of security procedure set forth in a written agreement with the credit union member. The callback verification required that the credit union verify a requested funds transfer by using a secure telephone number to contact the credit union member. Well, unfortunately for the credit union, the telephone number on the account had been changed by an identity thief only 5 days before the fraudulent wire transfer, and the bond agreement required that a replacement number be in existence at least 30 days prior to receipt of a wire transfer instruction. When bank officials called the replacement number, they actually were talking with the identity thief who verified the wire transfer. The credit union also tried to argue that the fraudulent written documents requesting the wire transfer, those constituted the alternative written agreement with the credit union member, an argument easily dispatched by the court since the documents were conceitedly forged. A document signed by the identity thief does not constitute an agreement with the credit union member. So the credit bond company is off the hook and the loss lies with the credit union for failing to use the appropriate security procedures. That's it for today's Kelso Report. Have a great day in the law.